Keynote. This is Dan Lear. Dan Lear is a lawyer, blogger, and a legal industry gadfly. Is that how you say that? Gadfly. He is a Washington State licensed lawyer who practiced technology law for 6 years in Seattle. He is currently the director of industry relations at AVO, and that's a role he took in 2014. So without further ado, Dan Lear.
I brought my cheering section. So, back in the mid-'80s, Steve Jobs was trying to convince John Sculley, then the CEO of Pepsi, to leave his current cushy job at Pepsi and join him at his still fledgling but fast-growing computer company, Apple. And at this time, Jobs asked Sculley this now famous question. Do you want to spend the rest of your life making sugar water, or do you want to come with me and change the world? And, speaking of changing the world, I think law school is a pretty cool place to go to change the world. Thank you. I think this is one of the best places, in fact, to be a launching pad or an incubator or a laboratory for folks to figure out how to change the world. Because the law is all around us. You buy something at the grocery store and you've entered into a contract. You cross the street and you accept and waive liability. You drive in your car, you play a sport, you buy a house, you go to a website. You're always interacting with the law. And in some of those cases, that interaction, it's pretty fluid, it's pretty easy. Sometimes we don't even notice it. But in other cases, the law is really broken. In situations like we're seeing with Black Lives Matter, or in recent controversies over free speech versus hate speech, or just even some of the cultural biases that are implicit in the law. There are a lot of really fundamental problems with our law. And frankly, some of those big problems, like the ones I just mentioned, technology can maybe help, but I'm not sure that they're the solution. But the good news is there are a lot of really big, really important, I think really interesting and fun problems that the law can help us solve. And so I want to talk through a few of those today and kind of tease them out, and then hopefully give you some ideas about how you all can use some tools to attack some of these problems. So here's the list of problems that I want to chat through with you today. And I'm going to start with this notion of open legal information. So I don't know, are folks here familiar with Fastcase? Yeah, no, maybe some. I gotta see a few hands. So Fastcase is kind of an upstart legal research company. They do great work, particularly with bar associations. And their CEO gave a great talk, which I won't even try to mimic because it's way better than I could do. Plus, this gentleman, Ed Walters, he knows this area very well. But he gave a great talk about who owns the law. You can find it on Vimeo. And I want to just steal two quick stories and talk very briefly about sort of this notion of ownership of the law that he talks about that I think is very important to us, and particularly to this problem of open legal information. So he talks about a program called Flight, which came out of some Department of Defense wing that ultimately made its way to the Department of Justice in the early 80s. And it was called Juris. And this thing was actually pretty revolutionary. It was one of the first online legal research tools. It was a way for the Department of Justice to share almost an early knowledge management tool for legal research. And they would share information about legal research that they'd done. And they had this really powerful tool, but they had sort of gotten past their ability to manage it and do much with it. And so I'm not sure whether Thomson Reuters came to them or they reached out to Thomson Reuters. This is the owner of Westlaw. But they said to Thomson Reuters, hey, we should worry about putting bad guys in jail. We need somebody to manage this online legal research tool. And Thomson Reuters said, great, we will take this thing that you have created, this law, and we'll manage it for you. And what they did through this management process is they inserted some head notes and most, I think, prominently even just page numbers. And a few years later, the Department of Justice came back to them and said, okay, hey, it's time for us to re-up our contract. I think we might want to go a different direction with this corpus of legal information. Thank you very much, we're going to go on our way. And Thomson Reuters said, not so fast. You see this line here in the contract? It says, effectively, and I used to be an intellectual property lawyer, now I get to do this fun stuff, and so I like you IP folks in the room, you can keep me honest, but if it said effectively, any material commingled with Thomson Reuters material becomes Thomson Reuters property. And so they effectively walked out the door with what was the Department of Justice's law, what was our law, and kept it for themselves. A similar story happened in Georgia. The Georgia legislature engaged Reed Elsevier, which is the parent of LexisNexis, to manage and put headers on the Georgia code. And Ed tells a great story about when he did a deal with the Georgia bar and to give fast case to their members. And the Georgia bar said, hey, we'd really love to have the Georgia code in your corpus of information that you provide to our attorneys. And so Ed went to the Georgia legislature and said, hey, folks, can I get a copy of the Georgia code? Want to put it in fast case so that we can make it available to Georgia bar members through their program. And the legislature said, yeah, you're going to have to go talk to Reed Elsevier, to LexisNexis, because they own the Georgia code. And Ed said, okay, no, guys, that's public information. Ed's actually written a law review article on the fact that state legislative materials cannot be copywritten. So he said, okay, well, I know some friends at LexisNexis. I'll go call them up. And I'll find out, what I need to do to get this content. So he called him up and he said, hey, the Georgia legislature tells me that you own the Georgia code. And, we just want to get a copy of it so we can make it available to the Georgia bar members. And they said, actually, as a matter of fact, we do own the Georgia code. And Ed said, what? And they said, yeah, no, we own the Georgia code. And so Ed said, all right, that's fine. Let's say for sake of argument that you do own the Georgia code. What is it going to cost me to license it from you? Because I know you probably license it to other people. And they said, we'll get back to you. And a few months later, they got back to him and said, basically, we're not licensing it to you ever. And again, the reason was they had put these headers in that effectively made the Georgia code the property of Reed Elsevier. Now, I do think that these examples are somewhat limited. But the point is, in many cases, even if we do have property of our own code, or if we have control of our own code or our own laws in many cases, it's not made freely or openly available. It's not made available in formats that we can do anything with, that innovators can use and innovate on and build. I like to use the analogy, even if we do have it, it's not free. And not free as in free beer, but free as in open, free as in freedom. And so even if we do have control of it, we still are not making the best use of it as we can. There is some light at the end of this tunnel. And again, those are just two sort of negative stories. But the former general counsel of the District of Columbia, a guy by the name of Dave Zvenyach, who now actually does a lot of this work out of 18F, which is a federal agency that does a lot of interesting work in this space. When he was the general counsel of DC, he had a bunch of sort of civic hackers come to him and say, hey, we want to get a hold of a copy of the DC code to sort of play around with. And he noticed that just at that time, their contract with, I think it was one of these two publishers, was coming up. And he went back to them and renegotiated the deal so that they pulled out all of their stuff and handed them a usable, free and open copy of the code that a lot of the civic hackers in DC could ultimately use and make available. But this is a huge, I come back to the point that this is just one problem, one of the many opportunities that we have to bring technology to law and to make this information more available and more open. The next one I want to talk about quickly is finding a lawyer. So I don't know if folks are super familiar with Avvo. That's the company I work for. We're a marketplace for attorneys. We help consumers find a lawyer, and we help lawyers get clients. And the story of how we started is actually really interesting. So we were started almost 10 years ago by the former general counsel of Expedia. And he was on a trip in Italy. He'd worked for Expedia for a number of years, had left, decided to go vacation for a few months, and so he's on a trip in Italy. And he was based in Seattle, Washington, where I'm from. And he kept getting all of these emails from people back home asking him for referrals for attorneys. Now, he had been formerly a big law corporate attorney. He'd worked in-house at a large technology company. They weren't asking for securities attorneys. They weren't asking for venture capital attorneys. They were asking for family law attorneys. They were asking for attorneys to help him with help them with property disputes and all sorts of like really things that were completely outside of his area of expertise. And he's sitting there in Italy and he thinks, listen, if the best people can do in order to find a lawyer is to reach out to someone all the way on the other side of the world and ask them for a referral, there must be a problem here, or there must be an opportunity. And so what we did at Avo was we built a directory of every lawyer in the country based off of publicly available bar association and licensing data. And we put that on the web so that consumers could have more transparency about the lawyers that they were choosing and just basically learn more about them. Now, another thing that we did, and I'm not going to talk about Avo in any great detail, is we provided a rating for those lawyers. And this makes lawyers very grumpy, and I'm happy to talk about it in the Q&A. But in all honesty, it was a revelation for consumers because they have no idea how to assess whether one attorney is better than the other. And so even just this modest step that we took to give consumers greater transparency, and our rating is, at least one big piece of our rating is simply based off of disciplinary data. Just to give consumers a little more transparency or a little more insight into that process of choosing a lawyer. And frankly, while I'm very proud of the work that we've done, this is the smallest step. I mean, if you think about it, all of this data has been available for years, and all we did was put it online and assign some kind of random numerical score. There is so much more work we can do, and frankly, so much more opportunity in helping people connect with the legal help that they need online and using technology. It gets me excited. And again, I'm very proud of the business we've built, but this is another huge problem that many of us, or many of you, I hope, will take up and begin to work on. So open court data, this is another really interesting one and one that gets me kind of excited. So there are a couple of companies that have started working on this problem, but they've only been doing it sort of at the high-end space. A company called Lex Machina has been doing a bunch of interesting data analytics and kind of number crunching on the intellectual property dockets at the federal level, mostly because that information is available. So they're doing interesting analytics and sort of beginning to sort of figure out whether certain briefs or whether certain cases in front of certain judges are more likely to be successful or not. Ravel Law has also done some interesting things. In the nonprofit space, and this is the space that really gets me excited, there's a nonprofit called Measures for Justice. Are folks familiar with, they're based out of the East Coast somewhere. Okay, I'm seeing some, oh, are they here? Yes. Oh, hey, you guys are awesome. So I'm gonna talk about you guys for a minute. And also sitting right beside them is another rock star in this space, a guy by the name of David Koleru, whom you're going to hear from later. And while I think it's really interesting to see sort of the for-profit models that we've seen from Lex Machina or Ravel, and I've thought about this from the Avo perspective as well, but I think things get really interesting when we start analyzing local court data. Because that's like the blood and guts of our legal system. That's where the law actually touches people in a really meaningful way. And one thing that David Koleru did is he did an analysis, and I'm gonna probably totally butcher it because I'm not a data scientist nor really a strong mathematician, so David can correct exactly what he did later. But the very simple story about what he did is he took some analysis of verdicts in Virginia, or he did an analysis of verdicts in Virginia and looked across race and income brackets. And this is another picture of David. This is an old one, but is that still your Twitter bio? Okay, excellent. But the outcome of this analysis was that for a black man in Virginia to get the same treatment as his Caucasian peer, he must earn an additional $90,000 a year. And I don't want to make sort of light or minimize what David's done. This was incredibly important. But this is in one set of courts in one jurisdiction. There are courts and legal systems that are touching our fellow citizens all across the country, and we are flying blind as to the way that these courts affect people, the way they treat people of differing races, of differing income brackets. We are completely blind. And let me tell you, it is no small feat. I mean, I've started looking into this, and again, the folks at Measures for Justice can talk at length about this. But we could get so much, and I think there's a business opportunity here. I think there's a transparency opportunity here. I think there's a social justice opportunity here. We get so much insight if we just knew how long it took for certain cases to make their way through the court system. If we knew whether certain judges take a lot longer than others, and that's not even to sort of penalize those judges, but maybe give them some feedback on how long it's taking, on whether certain defendants of a given race do better in front of certain judges or others. There's so much information and so much opportunity. But the first problem that we have to do, and that we have to solve, is that all of this court docket data is in a wide variety of formats, sometimes made public, sometimes not. And again, this is the problem that the folks for Measures for Justice are tackling. But it's another one that I think folks like you are in a great position to begin to try to figure out how to solve. I really don't have much to add after this morning's sessions on online privacy. But I think this is such a fascinating topic. All I could keep thinking about has anybody in here, folks watched Black Mirror? Okay. It looks like it's gonna be over, and I am so sad because and it is, in my opinion, it is so prescient. It is so fascinating. But just the whole notion of what privacy even means today. And the Europeans are trying this right to be forgotten. There are these questions around red cup photos, or I don't know if people have heard about that, but what do you do? I mean, we always knew that people did stupid things when they were in high school or in college. I definitely did stupid things. I was talking with one of my colleagues at work, and she's like, I did stupid stuff that I would never have wanted to have had captured, let alone made available for the world to see forever and ever. But I don't know really how we're going to deal with that. I think there's also a really interesting question about, and this came up in the panel earlier, about should we give people a meaningful opportunity to consent to the way that their information is being used beforehand, and instead of sort of after the fact. And I think one of the most interesting questions around that question is, how do you do that in a way that is meaningful? There are plenty of privacy statements in the world, but I used to read those for a living, and I had trouble with them, and I am very educated. So how do we help people understand what they're actually agreeing to and what that means? It's a huge problem that I think folks like you are primed to solve. So people talk a lot about access to justice, and I've gotten a little frustrated with this term for a variety of reasons, and I won't go into it at length here. But I want to plant a small seed in your mind, which is, I think what we should be striving for, or I would hope that we can reframe at least part of this discussion as meaningful access to the legal system, or really maybe even meaningful access to problem solving. Because in so many cases, the definition of justice varies so widely, and what an attorney who's seeking justice might be out to get might be very different than what even their client believes they need to get their problem solved. I also think that one of the problems with this notion of access to justice is that we've sort of fallen into this barbell approach, where there are people who can afford legal services and there are people who can't. And the people who can't, we give them a lawyer, and the people who can, we give them a lawyer too, because they pay for it. I think there's actually a much more, and again, I speak from a bit of an economic perspective as well, because as we at Avo think about how to connect consumers with lawyers more effectively, we think about things this way. But I fundamentally believe that this should be more of a spectrum, and that we should be looking for opportunities all along the way for people to pay some, because people are rational. And if you can provide a compelling reason for them to sort of purchase a legal service or deal with a legal problem for a fair price, in some way, technology enabled, somehow, I think people will do that. And so I would encourage you, not that I'm not for access to justice, but I would encourage you to think more broadly about that problem, particularly as you go about trying to solve it. And finally, the future. there are so many interesting issues on the horizon, whether it's the sharing economy, another great movie or a great TV show. Yeah, also had a Black reference in it. Orphan Black, right? Cloning. I think the promise of AI and the questions around ethics and algorithms are really fascinating. And I know Oliver loves the blockchain. And I think the blockchain is going to be really interesting, and I'll talk about that in a minute. But there are so many interesting areas where, again, you can plug in and have such an impact as lawyers, as alums of this, or even as students of this school. So what kinds of things can you do? I want to share 4 tools with you that I think you can use. Some of these are a little higher level, some are a little more specific, that you can use to attack these problems or try to solve them. The first thing I want to talk about is applying the hacker ethic. So these actually aren't the original hackers. The original hackers aren't even these folks. It turns out that these are the original hackers. And that hacking really isn't, by its very nature, malicious. It's important to remember that the hacker culture sprung from, of all places, the Tech Model Railroad Club at MIT back in the 1950s and 60s. So these trained hobbyists, they loved circuits and switches. And they, as folks at MIT still do today, they got super excited by doing crazy things with these circuits and switches to make their trains go faster in increasingly complex ways. And so then, as large, room-filling combinations of circuits and switches, also known as computers, started to appear on the MIT campus in the 50s and 60s, they were like, to hell with trains, right? Look at this thing. And they embraced these computers. They embraced this new digital revolution with sort of this gusto and this passion. And it was almost cult-like in the way that they would, the stories are legendary about how they would stay up all night just to get, because you had to schedule time on the computer, so they'd stay up all night to get, an hour of computing time at 2 a.m. or 3 a.m. when the computers were free. But what really evolved from this was this ethic, which I want to talk about in a minute. But before I do that, I just want to go back and say, so the evolution of hacking, as we think about it, sort of went from here to here to here to sort of the Jobs and Woz to these guys. But in some ways, the term has been corrupted. But they're developed this ethic about the way that they approach these computers, the way that they were exploring this new frontier. It began to represent like an ethos or an approach to life. And Stephen Levy, who's written a great book on these folks, a journalist and author, said about hacking, hackers believe that essential lessons can be learned from taking things apart, seeing how they work, and using this knowledge to create new and interesting things. This is especially true when, from the hacker's point of view, something is broken and needs improvement. Hacking was a quest to improve the world by understanding and building systems. And finally, Levy wrote, wouldn't everyone benefit even more by approaching the world with this same inquisitive intensity, skepticism toward bureaucracy, openness to creativity, unselfishness in sharing accomplishments, urge to make improvements, and desire to build as those who followed the hacker ethic? So let me give you 2 examples of these early hackers that I think are really, they're kind of fun, and I think they're also illustrative of some of the ways that this hacker ethic comes in conflict with the way that frequently we as lawyers are taught to think about the world. The first is this story that I like to call expensive desk calculator. So one early hacker was forced to use a clunky electromechanical calculator to do his homework for his numerical analysis class. Now, I don't know what an electromechanical calculator actually is, but I imagine, this dates me, but also predates me. I imagine it looks something like those old typewriters that like have the thing that swings up when you hit the button. Like, I imagine it was a really painful thing to use. So this guy, he thought it was ridiculous that he had to use this electromechanical calculator for his numerical analysis homework. So instead, he wrote a program that basically mimicked the function of this electromechanical calculator, and ran it on the computer that he had access to. Well, he did his homework and he turned it in, and the teacher refused him credit, saying, "You used a computer. This can't be right." I think that this approach is problematic from a number of places. The first thing that I think is so fascinating about this, and I think is one place where you folks are fortunate to have great professors here at Vermont Law who see the vision. But I think this teacher missed the fact that in coding a machine that mimicked the way a calculator works, this individual demonstrated far and away his competence, his mastery of this system, right? If you can build a machine that does the homework, I'm pretty sure you understand the way the homework needs to be done. And I've talked actually at length with Jeannie about how law, really, in my opinion, and I was not the greatest law student, so take that for what it's worth. But I think the law, and maybe this is why, because I got really frustrated with all the time we were spending in law school, but I think that law is just a series of if-then statements. It's just a series of logic trees, in the same way that code is just a series of if-then statements. So what better way to teach lawyers to understand the law than to have them put it into code? I think there's also some fear of the new with this professor. Going back to blockchain for a minute, I remain confident that blockchain, as much hype as it's getting, it's going to be a revolutionary technology that's going to change the world and the legal sector. I really believe that. But a lot of lawyers who aren't familiar with it may look sort of, down on it and say like, oh, well, look at the day-to-day or even month-to-month fluctuations of something like Bitcoin. Like, it's just a fad. This can't be real, which I think is just really short-sighted. Similarly, a lawyer might use something like Siri or these other assistants and see that so often they don't understand what we're saying or what we want from them and think, oh, this AI thing, it's not going to go anywhere. I think the promise of both of those technologies are significant, and we're just still in such early days. I think in a grander sense, though, the professor was also almost raising a moral question. Is it right? He said, this can't be right. Is it right to use a computer to complete this work? And I think the same thing might be said about coding the law. Is it right to do that? Is it right to look at the law as an algorithm? And I fundamentally believe it is, with a very small asterisk, and here's the reason why. As we look to scale, whether you want to call it access to justice or access to legal services, we must find a better way than simply finding a lawyer for every individual. And if we can build out algorithms, if we can take the hacker ethic and build systems that will process this information, and then as lawyers step back and ensure that these systems are providing fair outcomes, that's both the best use of our time and our trained brains and the best use of the technology that we have. So I absolutely think it's right. Let me tell you one other quick story, and I just got the 5 minutes, Chloe. I'm gonna go to like 10 till. Hope that's okay. Let me tell you one other quick story. I got 3 other suggestions, and then we'll move on. The next story I like to call theory versus practice. So one young hacker, David Silver, was a 14-year-old 6th grader, you heard that right, who had been held back twice. Some said he was dyslexic, but he just claimed he wasn't interested in teachers or school, and instead he wanted to build systems. So Silver he started hanging out with the hackers, he gained their trust, and one of his projects that he built was a little robot that when you dropped your wallet on the floor, this robot would like scan the floor, and it would scoot forward and find the wallet, and it would push it into a little pen. I mean, it looks like a crazy Rube Goldberg machine with like antenna coming out and hangers and all this stuff. Well, the hackers had sort of some arch rivals at MIT back in those days, and these were the AI theorists. Even back then, MIT, prescient as they were, sort of forward-thinking, they were thinking about this kind of stuff. And the AI theorists hated the hackers for lots of good and some sort of unfair reasons. But when they saw this little bug thing, they just went nuts. They said, this is a liability, this is dangerous, like we need, this kid isn't even enrolled here, like we need to shut this down. But the hackers knew that that really wasn't the complainer's main concern. Silver's bug in finding this wallet and pushing it into a pen was doing the things that the AI theorists said were impossible. A 14-year-old boy, had sat down, rolled up his sleeves, and by applying the hacker ethic, not only proved them wrong in theory, he'd proved them wrong in practice. And that's what they found most offensive. So I think this also exemplifies two other problems with the legal mindset that really conflict with the hacker ethic. The first is that we are an eminence and not evidence-based profession. And I could talk about this forever, and I actually give a hat tip to my friend John Grant from Portland, Oregon, who's sort of been popularizing this idea. But very briefly, as an eminence-based profession, we give very short shrift to data, we give very short shrift to math, we give very short shrift to a lot of these tools that are increasingly powerful and useful to us. And instead, we frequently bow to precedent. Judges or senior partners are always right. Our law professors, as lovely as yours are, we assume that they're always right. And we tend to do what we've always done, and maybe we trust the system just a little too much. Another just quick example of this, there was a great article, I'm a big fan of 538, folks read 538 around here? There was a great article in 538 just a few months ago about how the Supreme Court is effectively allergic. They said, I think it was titled, "The Supreme Court is Allergic to Math." And they were talking about a gerrymandering case that may have already come before them, but I don't think it's been decided or will soon come before them, in which there's some pretty complicated, it's actually not that complicated, math that's being applied in order to determine whether or not a district has been gerrymandered. And I know the political leanings of most of you in this room, and let me tell you that this is not the justice that you think it is, who said of this math and of these analyses, he called this data science effectively social science gobbledygook. And to me, that seems a little bit short-sighted. We have so much evidence, so much information that we can use to give ourselves better insight into how we can actually help people. So to sort of dismiss it out of hand, I'm not sure is the right move. I want to give a quick shout out to the legal hackers movement. So this is a group with now more than 8,500 members. So these are lawyers, technologists. I'm not sure if there's a group here, but I know David runs one in Boston. There's 60 chapters on 5 continents, the largest grassroots legal innovation community in the world, and an integral piece of the legal technology movement. Look, legalhackers.org, you can find them really quickly. I'll just blast through my last 3 really quickly. I suggest that you think about creating a portfolio, and that may sound kind of like a funny recommendation or something that only art students do. But listen, there's never been an easier way to synthesize your ideas and share them with the world. In my opinion, blogs are the new law review. Because who's ever gonna read a law review article that you put together? And that presupposes that you get on law review. You can today, you can tomorrow take your ideas and put them on the web, and then when you go to get a job with anyone, you can say, hey, you wanna see what I think about any issue? You wanna see how well I think about certain topics? Go look at my blog. I've dissected legal issue after legal issue there. And you don't even have to do it with blogs. If you're into coding, you can use GitHub and start throwing up your tools and your ideas up there. You can use YouTube and put videos up. You can use Twitter. I've done entire webinars on how Twitter changed my legal career. You can use Facebook, you can use Instagram, but build a portfolio. Find some way to tell the world about who you are and to begin to push your ideas. Build an audience. So this really goes hand in hand with this portfolio notion. But once you start getting your ideas out there, the beautiful thing is someone's actually listening. People may actually start to believe you. And frequently, and I've learned this many times in my career, it just takes someone stepping forward and saying something. So after you start to create a portfolio, think about building an audience. Think about rallying or finding, or if you don't want to think about it as an audience, think about it as a community. Rallying your friendlies, your troops to sort of help them help you accomplish the goal or solve the problem that you want to solve. And finally, cultivate resilience. I don't have to tell a room full of millennial law students that you'll only stay at a job for a relatively short time. I think we all know that the nature of work is changing dramatically. And so, yeah, you gotta be ready to change and be adaptable and flexible, but I would also say in this, embrace failure. I haven't actually read the book yet, but I listened to a great podcast from Ray Dalio, who's the well-known hedge fund investor, who said, I have reprogrammed my brain to view failure as success. And I think we could all, if we really want to figure out how to solve some of these really gnarly but really interesting problems, we've got to figure out how to be okay with coming up with the wrong solution before we come up with the right one. So in closing, I want to give you a quote from Peter Drucker. He's a well-known management guru, and man, this thing just gets me jazzed up every time I read it. So Drucker said, "The steam engine reached its greatest social impact around 1840 with the railroad and steamship. Technologically, it was completed almost 60 years earlier." And then Drucker goes on, "After approximately 60 years, the speed of progress of any technology slows down very sharply. But that is when its social impact begins to gather momentum." So Drucker, though, wasn't just a railroad nerd. He also had a long-standing relationship with the folks at Intel. And of our time, he said the following: "I expect by the year 2010 to see the end of the gee-whiz high tech and the beginning of the information society," right? So if 1780 is when the technology was completed, but it had its greatest social impact in 1840, similarly, the technologies that are changing, or certainly some of those that are radically reshaping our society, they were perfected 60 years ago. But it's only in 2010, and this is what he said, "see the end of gee-whiz high tech and the beginning of the information society." And the question is, and this is what I want to leave you with, what will the dominant groups be like? What will they need to be able to function, to achieve, to contribute, and to set an example of a good society and a good life? I think we've reached that point, and we've seen that, like with Moore's Law has sort of been declared finished. So the speed of technology is slowing down, just like it did in 1840, but this is the moment. This is the time when the greatest social impact of this technology will be realized. And as lawyers, as technologists, the tools are in your hands. And so, like, really to put this in other terms, will we continue to, or will we go and seek the opportunities to make sugar water, or will we change the world? Thanks a lot. So Chloe, do we want to be done, or do we want to do questions?
We're happy to do questions.
I'm totally happy, but I don't want to.
All right, that was awesome, Dan. Thank you.
Yeah.
So, questions? Anyone?
Or maybe you're all like sessions.
Yeah.
Yeah. Hello, Mr. Lear. Thank you for joining us this afternoon. Appreciate your talk. I'm curious about Avo, though. Crowd-based review sites tend to walk a very narrow line of being a social benefit and a business encumbrance. So I'm curious how Avo distinguishes itself from Yelp in light of Yelp's kind of bad actor culture that makes it difficult to distinguish Yelp from a neighborhood group of mafioso extortionists.
I'm pretty sure I'm not a mafioso extortionist, but you get to make your decision about that. I mean, you're exactly right. We walk a fine line. And I mean, there's really a much bigger question here, which I will try to answer very briefly and then get to your point about our business. I mean, the transparency, I mean, I frequently describe what I do traveling, and I don't frequently give talks quite like this. I usually end up talking at least some about Avo or what our business does. And the way I describe what I do is I frequently go around the country apologizing to lawyers for the existence of the internet. Because the power of the transparency that we now have, now whether we as a society are using it effectively or to the best of our ability is an open question. And I think, listen, there's lots of room for other entities to come in and do what we do, or do what any of these for-profit entities do better, what any of these mafioso extortionists do better. I fully admit that. In the meantime, we have filled that gap. And to be quite frank with you, we still get from bar associations lists of their attorneys in Excel. They don't even publish it on the web. And to some extent, that's not because, sometimes it's because they don't want to. But sometimes it's because they don't have the resources to do it. And I am firmly of the opinion that having that information out there, now whether we do it in the best way we could, that's open for debate, or in the best way that could be done. I fundamentally believe that having that information out is way better than having it not. As it relates specifically to our review system, I'll just talk to that really quickly. We try to be as fair as we can. The reviews that come to the top are those that, and this is where I'd need my product folks to check me, but it's either those that are the most viewed or those that are the most recent. We do have a pretty fair and open process that lawyers can use to dispute reviews. We go back to the client and we ensure that they can document to our satisfaction that this individual was indeed a client of that lawyer. So not everyone can leave a review for any lawyer. And frankly, we also rely, and this is something else that I talk about at great length, we also rely on attorneys' ethical responsibilities to behave themselves on the internet. It's false and misleading for them to leave false and misleading communications, which is a breach of their ethical duties, to leave false reviews either for themselves or for other attorneys. And we've actually found that self-policing mechanism works pretty well. So there's a very brief answer, but happy to talk with you more later.
Okay, fantastic. Are there any more questions?
Hi, I'm Kevin Gillespie, text to lawyer. I had a question about your review system. I've recently worked with some consultants on a different website, Upwork.com. Are you familiar?
I know what Upwork is, but I can't say that I know it's blood and guts.
I had a dispute with, you were talking about your dispute process is open and fair, and I'd just like to maybe hear a little bit more about that after my experience with this other website where their top-rated workers can have a review removed every couple of months if they're a top-rated person.
Yeah, so we don't allow attorneys to, well, in some limits, so we don't allow attorneys to remove reviews. Minor asterisk, I'll come back to it, I promise you, it's not an issue. We don't allow attorneys to remove reviews. What we do is when a review is submitted, and they're submitted anonymously, the attorney has a chance to review the review and determine whether they want to dispute it. And actually, the review goes up before they have a chance to dispute it. If they then dispute it, as I just suggested, we go back to the client and we ask the client to document to our satisfaction that they were indeed a client of this attorney. We also have, we have guidelines. So like you can't just go on some sort of expletive-rated, laced tirade about this attorney. Like you've got to actually be saying something substantive and that would be helpful to others in making a decision about whether they would want to hire that attorney. But if it meets our guidelines, it goes up, and then if it's challenged, and we can document to our satisfaction that they were indeed a client of that attorney, then the review will stay up. Now, in some minor exceptions, we remove reviews, and this is the truth. And I actually don't know if we've ever removed them, but we've certainly entertained this notion. In some cases, some reviews say something like, Dan is the best lawyer in Vermont. And in some cases, that's a violation of ethics rules for the attorney to say, because they have to have some kind of documentation of that. So in some cases, if the attorney comes to us and says, I want you to remove that positive review because I'm worried that it could compromise my ethics situation, then in some cases, I think we've entertained removing them, but that's the only situation. Yeah.
Okay, thank you very much.
Sure.
Okay, great. Thank you so much. We're going to go ahead and get started with our fourth panel.